Hi, I'm Audrey, and today I'm here to talk about the Supreme Court's ruling in the 2022 case Shoop v. Twyford. This Tuesday, the court struck down a court order sanctioning transport of a prisoner for neurological testing in a search for new evidence that might mitigate his sentence. In 2003, Raymond Twyford, a man on death row for aggravated murder, filed a habeas petition challenging his sentencing. He alleged that his counsel at trial was ineffective for failing to present evidence about a head injury that he sustained as a teenager. Twyford claimed that this injury could have caused neurological impairment that hindered his ability to make rational decisions, and so he asked for permission to be transported to a medical center for neurological evaluation. The district court granted Twyford's request under the All Writs Act, which is like a blanket legal order. The act gives courts the power to issue writs, which are orders that command action, so long as these writs are necessary and appropriate in aid of their jurisdictions and accord with legal principle. The act goes all the way back to the 18th century, when it was enacted as a part of the Judiciary Act of 1789, and historically was commonly applied. Now, however, it's usually reserved for established or extraordinary circumstances where the law doesn't already address the situation in question. In a 5-4 ruling, the Supreme Court struck down Twyford's transportation order. The justices did so on the grounds that Twyford had not proved that his medical evidence would be even admissible in court. Under the Anti-Terrorism and Effective Death Penalty Act, there are strict limitations on what new evidence a federal habeas court, that is, a court that decides if the state is validly detaining a prisoner, can consider. Twyford also had to prove that if he gained the desired evidence, it would be clear and convincing enough so that a reasonable person examining the facts would not have convicted him of his charges. That's a pretty high bar. The reason? For one, searching for ultimately inadmissible evidence could needlessly prolong a case, as held in Shin v. Martinez-Ramirez, and as the court noted, it could also present unnecessary risks to the state. Under this standard, Twyford's case hit a snag. Twyford hadn't explained how his test results would be admissible at court, nor was it particularly clear that the gathered evidence would sufficiently support his claim. In a dissent joined by Justices Sonia Sotomayor and Elena Kagan, Justice Stephen Breyer argued that the court should not have decided the merits or central question of the case. That's because Twyford's case is an interlocutory appeal, an appeal launched before the trial court makes its final decision. These types of cases are only allowed under specific circumstances. To hear Twyford's case, the court had to expand the collateral order doctrine, which allows courts to rule on a small class of interlocutory appeals. In his dissent, Justice Neil Gorsuch cautioned against this practice, as Justice Breyer also had. And so that's a summary of Shoop v. Twyford. I hope you enjoyed watching.